May it please the court, Austin Watkins appearing on behalf of the state of Tennessee. If I could, Your Honor, I'd like to reserve 3 minutes for rebuttal. The post-conviction court's grant of relief in this case was flawed for 2 reasons. First, the lower court erred by granting due process tolling of the statute of limitations based simply on attorney error. Second, the lower court erred in granting or finding that the petitioner's constitutional rights were violated without proof by clear and convincing evidence that those alleged violations actually occurred. Therefore, the lower court's decision should be reversed. Your Honor, turning first to the jurisdictional issue involving the statute of limitations. Tennessee law and federal law is clear that attorney miscalculation categorically cannot constitute extraordinary circumstances. The facts in this case establish nothing more than attorney error with regard to calculating the statute of limitations. I can go into the facts to the extent it'd be helpful for the court, but I do want to start essentially with the Tennessee Supreme Court's decision in Whitehead, which sets forth the test that this court is very familiar with for post-conviction statute of limitations. There's 2 prongs. There's a reasonable diligence prong, and then there's these extraordinary circumstances prong. And the cases are very clear that the extraordinary circumstances must be extraordinary, that this is a very high bar that is only appropriate in very rare situations. And I think that the parties, do not dispute reasonable diligence of the petitioner here in pursuing her post-conviction rights. Although I do think to some extent, if you kind of comb through the record, you see how these prongs and the lower court's analysis of the prongs bled together a little bit. But so if you set aside reasonable diligence and just focus on extraordinary circumstances, what the cases say, what Whitehead makes clear, and it was relying on federal habeas corpus law from the Supreme Court of the United States and Holland versus Florida, and then I think a case, Maples versus Thomas, that kind of adopts a concurring opinion in Holland from Justice Alito. The rationale in those cases for how courts should, delineate between what is an extraordinary circumstance and what kind of has been dubbed a garden variety claim or neglect, they point to the agency principles. And they say essentially if the attorney's errors were committed within the normal scope of the functioning attorney-client relationship, then that is something that is not extraordinary, and it cannot constitute a basis for tolling of the statute of limitations.
I don't want to, my problem is I want to ask a question and interrupt you, so I apologize.
You're welcome to do so, please.
The trial court was very well aware of Whitehead, the law that you cite, agency law, and, that attorney negligence does not amount to extraordinary circumstances. So can you kind of flesh out here really what the trial court was getting at? If we have more than attorney negligence or miscalculation, which does not satisfy the cases that you cite, what the trial court was very well aware of what the law is. So can you speak to that?
Yeah.
That's what's troubling me.
Yes, I understand, Your Honor. I'll do my best. I think the court probably had a reaction that was similar to how we all have, which is, oh, wow, these 4 attorneys, and many of them are very distinguished attorneys, gave this individual the wrong advice about the statute of limitations. And this is not really a confusing area. I mean, it's confusing to the extent that the state statute of limitations runs differently from the federal habeas corpus statute of limitations. But the state post-conviction statute is very clear about when the clock starts, and the case law is clear about that. And so I think the court looked at some language in Whitehead that talks about fundamental fairness and when it would be unconscionable to hold these errors against the petitioner, and just said, I am astounded by the scale of this miscalculation such that I believe due process tolling is warranted here. And so I can understand that, but so I think if you look at it, Your Honor, that even if the fact pattern here is extraordinary within the realm of miscalculation, we acknowledged I couldn't find any cases in Tennessee that had to deal with 3 or 4 attorneys giving the wrong advice. I cited some cases from other jurisdictions that treat up to 3 as essentially being the same as 1 error. So I'm happy to acknowledge that this is unusual in the scale of the error. But my point that I was trying to make, Your Honor, with talking about Whitehead and Holland and Maples is they focus not on the scale of the error or the effect of the error, but on the nature of the error. And what they do say is even if this was extraordinary for miscalculation of any scale categorically cannot be extraordinary circumstances for the test. So essentially what we're kind of looking at is it's almost a little bit of a cost-benefit analysis is maybe a little bit flippant, and I don't mean to be, but it's essentially the courts have had to draw a line to say at which point are we going to put the cost of this error on the state, on the opposing party who has absolutely no control on this relationship, and then at which point are we going to essentially say stick to the long held rule that your attorney, your fault. And so what they have said is we think it's appropriate that when there's a breakdown in the attorney-client relationship so that it is fundamentally unfair to essentially impute an attorney's conduct to the principal, to the client, when that attorney is ceasing to function as an actual agent because they're derelict in reporting the status of cases, misleading the clients as to the status of a case, for example, saying an appeal is pending when it's no longer pending, saying that someone is going to file a brief or a petition and then doesn't do that, or retains a client's files to prevent switching attorneys or pro se action despite repeated requests, or in the Maples versus Thomas case, wholesale abandonment. Attorneys leave private practice, don't send a forwarding address, don't withdraw. I mean, these are situations where the courts have said, okay, we're going to say this is a situation where it's the agency process breaks down, and instead of holding the client responsible for their attorney's errors, we're going to kind of in extraordinary circumstances hold that against the state.
I'm intrigued by your scale versus nature
Okay.
argument, but it does seem somewhat fundamentally unfair to a defendant petitioner if you go to one attorney and they say something and you're a little unsure, so you go to another attorney. And I know I'm just giving a hypothetical. That's not necessarily what happened in the facts of this case.
Yes, ma'am.
They give you the same advice that the first attorney did, okay? And you want to be absolutely certain, and you rely on a third attorney. I mean, so how far do we go before we say that advice that you got from 4 attorneys was wrong and hold it against someone whose life is basically on the line?
Right.
So I guess that's where I'm reading where the trial court was with the magnitude versus the nature.
Right,
of
and
the
I do believe that was the trial court's concern. And so the state's position is that is just unfortunately a misapplication of the Whitehead principles, and that the line is differently. It's at the nature of the error. And Judge, I do want you to consider what we pointed out in our brief, is that you've kind of said, well, if we get the 3 or 4 or 5, or say we've got 10 attorneys giving the wrong advice.
It doesn't matter.
No, I wanted to point out that think of all of the post-conviction petitioners that this court sees frequently who don't have access
to them either.
to
I don't like the fact that they're out of luck either.
Okay.
I mean, I understand your point. It's still fundamentally unfair.
Well, and I get that, but that's the whole purpose of saying it has to be something more than just an error. It has to be truly extraordinary. It can't just be, the statute of limitations is missed. Maybe there was a good reason, or what we have. When I cited a case in here, I think it was the Jones case towards the end of the argument on this section, which it was a first-degree murder conviction with a life sentence, and it was 1 day late.
1 day.
And so I understand your concern, Your Honor, but I do think we can agree that the cases are very clear that miscalculation by one attorney is not enough. And so instead of maybe stretching the rule for if we have someone who was probably in the 1% of litigants who are able to afford this much advice, that I think there'll be a lot of individuals, if they knew about that, would think that's a hard pill to swallow, especially when you look at all the other circumstances. Bad advice from prison inmates, prison legal aids, inability to speak English or at least as a primary language, lack of access to the law library, even in Whitehead, which dealt with pretty much a similar miscalculation but had other problems as well. Whitehead characterized itself similar to Holland as essentially attorney abandonment. It was an attorney abandonment case. But it said any of these errors alone is not enough, including a miscalculation about when the statute starts with regard to a cert petition. And so I understand that it may feel unfair, but the case law is clear that if the attorney-client relationship is functioning, even though it's a little bit of a fiction to expect a petitioner to double-check all the attorney's work, we assume the attorney is trusting, or that the client is trusting the advice. And that, though, that is what agency is there for, to say, yeah, well, you chose these attorneys. And if they got it wrong, but they were trying to, function as your attorneys, you're stuck with it. And so I don't think anything about the number of the attorneys or the fact that maybe there was some inconsistent advice here that's been pointed out about, well, she got the right advice first and then it changed when the procedure changed. It's all still the same. I mean, it all still resulted in the petitioner not knowing when the correct date was. And what these cases say when you really get at the rationale is that this type of error, miscalculation, when there's not a breakdown, and there can't really be a fair argument that these attorneys abandoned her, stopped functioning as her attorneys, that is something that the litigant must bear the result of, even in the criminal context, Your Honor, where liberty is at stake. I understand your concern, but that's what the law is.
Wasn't the petitioner told after the Supreme Court denied the petition to rehear, wasn't the petitioner told at that time that she had a year from that time to file a post-conviction petition, and this was prior to any cert application to the U.S. Supreme Court being filed, right?
She was told that regardless of whether she filed a cert petition, that the clock started from the denial of rehearing from the Tennessee Supreme Court. That was the first advice she got. That was before they had decided to file a cert petition. Once the cert petition got underway, the testimony, and it's a lot of affidavits really that were stipulated, that everyone kind of then assumed the clock changed with that decision to seek certiorari, and then there's a follow-up conversation on a phone call where she's given the wrong advice and says it starts from the denial of the cert petition, and then it was confirmed in an email. So we all agree that she got the wrong advice about it after having initially been told the right thing. So that's kind of the nature of the errors, Your Honors. I will move into the juror bias issue, Your Honors, and essentially the state's position is that the court, one, misapplied the law on presuming bias, but also erred in finding that there was clear and convincing of actual bias on this record. I think couple important things factually that I want to draw the court's attention to here in considering actual bias with regard to this juror. Jury voir dire at trial happened within the context of a pending motion to dismiss or motion to transfer the venue based on pretrial publicity. And the court had a hearing before the jury selection and then held that motion open until after jury selection. It was a little bit unusual, but that's what it did. You can read about it in the direct appeal. And so there was some proof and discussion about the pretrial publicity, at the hearing on that. So when the jury selection is happening, defense counsel, prosecutor, the court, everyone is aware that there's still a pending issue about pretrial publicity. And so I think that's relevant to kind of keep in the backdrop that when these jurors are being selected, everyone kind of already knows that the pretrial publicity for this case was very large in Sumner County, and there was testimony from a defense expert at that hearing on the motion to transfer that, if I understood it correctly, the defense expert, or the investigator is what it was, had called like a 4-month sampling of prospective jurors, and I don't think he said that almost 80% of the jurors had heard about the case, mostly from media. So I say all that to say the fact that a juror had heard about this case in and of itself was really, I think, pretty, not uncommon or unusual in this jury selection. We've cited in the jury selection situations of prospective jurors who said, hey, yeah, well, I've heard about this, I've made up my mind, I don't think I can set it aside, and they were excused. There was one other juror who had expressed a preconceived opinion about the case based on the media, and then said, but I've heard everything here today, and I think I can set it all aside and give this defendant a fair trial, and that person was seated as an alternate juror. And so I think that if you look at this questionnaire, if you think about the average people who are being called in to do jury selection and how they would understand things, she answered all these questions truthfully on the juror questionnaire and at jury selection, okay? And there's another important fact to remember, is there have been multiple weeks between when the questionnaire was submitted and was completed and when the jury selection happened. And
Mr. Austin, speak to the language in the questionnaire.
Okay.
Depending on what part of the state you're from.
Yes, ma'am.
Which was particularly suggestive of where the juror's mindset was.
I understand.
And the fact that trial counsel did not question her specifically about the words used in the questionnaire. I don't need to repeat it. And respectfully, Judge Witt, if I could let him answer.
I think I'm in my last minute. No, I understand. I think that language was blunt.
She lied and she killed, I think, her babies.
Her newborns, yes, her two newborns. If any of us have seen local news coverage of stories, it tends to be pretty sensationalized and one-sided. So if you imagine a mugshot being slapped up, and the record of what she saw or heard is not in there, but you can understand how an average person goes if you read the questions. Did you hear about this case beforehand? Yes, on the local nightly news. Based on your opinion, what have you heard? And so I'm kind of paraphrasing, but I think colloquially, well, based on what I heard on the news, it sounds like she lied and killed her two babies. I can see that coming from the police report if that was put on the news story. And so...
But you say it's fairly innocuous.
I'm not saying it's innocuous. I'm saying I think it's a direct response, and it's blunt. It's saying, based on what I heard, it sounds like she did this. Now, the sounds like language is not in the questionnaire. I'll give you that. But then she does go down and immediately answers questions saying, but based on my opinion, I can set it aside and follow the law. Okay, well, explain that. I'm an honest person and can follow the law. And then when she gets in jury selection, again, time has passed. She sat through an entire preliminary instruction from the trial court about the presumption of innocence, about the duty to be fair and impartial, about the duty to only make a verdict based on what they've heard in the courtroom. And then the questions she's asked specifically in voir dire by everybody except for about the language is, have you formed an opinion about guilt or innocence? And
So the fact that trial counsel missed it, and then expert attorneys testified at the evidentiary hearing that this juror should not have been seated, and the fact that trial counsel had a preempt left to strike her,
right.
We're supposed to ignore all that?
May I finish answering the question? I'm out of time, Your Honor. May I answer the question, Your Honor?
Yes.
I'm out of time.
Yes, go ahead.
Okay.
Go ahead.
I'm out of time, so I'm going to answer her question. I think, not I'll ignore all of it, but I think I've got two former prosecutors here who have sat here, done this, and understand how difficult it can be. I think when you look at the nature of her answers, at the beginning on that questionnaire, she said, based on what I heard, this is it sounds like what happened. And then when she's asked, well, after you've heard all these admonitions and you've completely, entirely, always said that I can be fair and impartial, set anything I've heard about aside, which other jurors said the same thing, she says, I can give this person a fair trial, and I have not reached an opinion about guilt or innocence, about how I'm going to vote in this case. I think those two things are perfectly reconcilable. It may very well have justified some follow-up questions about, hey, well, this language sounds kind of extreme. Are you sure you can set that aside? We don't have that, but because we don't have it, the standard now is higher. It's proof of actual bias. And the only other thing we've got in this record is this fist pump, which I'll acknowledge is unusual, I think, for a juror to make some type of gesture upon being impaneled. But it can mean a lot of different things, and it in and of itself can't be proof of actual bias by clear and convincing evidence. And when you look at the language in her questionnaire, we cited a case, it is a capital case, but it says just an answer in a questionnaire can't be the basis for a strike, for a causal challenge, without regard to the overall context of everything else from that juror and an opportunity to rehabilitate. And so it's unfortunate that in this case, this juror has not been able to explain herself, and that's in a kind of an alternative basis where we've asked the court that if it believes there is proof enough in this record that it at least needs to reverse and remand for this juror to testify. Thank you.
You've had your 20 minutes, General. I'll afford you 2 minutes of rebuttal time.
Thank you, Your Honor. I'll try to keep it brief.
Good morning, Your Honors. I'm Tyler Yarbrough. I represent the appellee, Lindsey, Brooke, Lowe. The facts of this case distinguish what the result needs to be. That's what Judge Gay said in his ruling when he granted the motion for equitable tolling to allow the petition for post-conviction relief to be filed. That observation that the facts of this case distinguish what the result needs to be could apply to all of the legal issues in this case. I'm going to start with the threshold issue regarding the statute of limitations. The post-conviction court correctly ruled that the constitutional mandates of due process required the tolling of the statute of limitations for the filing of Ms. Lowe's petition for post-conviction relief, filed just 35 days after the statute ran, to allow the court to reach the merits of her petition. The key facts as to why due process tolling should be allowed are really not in dispute. So yes, Attorney David Rabin handled the direct appeal, and once the petition for rehearing was denied by the Tennessee Supreme Court, he gave the correct advice in writing 2 times to say that the petition for post-conviction relief should be filed within a year. Then there was a decision by the Lowes to pursue a petition for writ of certiorari with the U.S. Supreme Court. That, in their minds, changed the timeline, because subsequent to making that decision, the advice changed entirely from every lawyer they spoke to. That would be the lawyer who handled the Supreme Court petition, Alex Little, the attorney who handled the post-conviction hearing and petition, and also from attorneys that they consulted, that they considered hiring. Those attorneys as well, 2 of them also gave the same advice, that as to the wrong advice as to the running of the statute of limitations for the petition for post-conviction relief. It's not insignificant, of course, that Ms. Lowe's father went outside of even talking to attorneys, consulting an online resource published by the Attorney General on their public-facing website to say, in that chart, it confirms the wrong advice yet again. All in all, there were 6 separate sources of information that the Lowes received that gave them incorrect information about the statute of limitations.
So what in this record do we have other than miscalculation?
So you have miscalculation, certainly, from the attorneys who were representing Ms. Lowe and representing her interest. And we certainly agree that there was no fundamental breakdown in that attorney-client relationship. At the same time, though, there were other sources of information that confirmed the miscalculation.
So you're relying on, again, going to the scale, the fact that additional lawyers compounded the original problem of miscalculation. I understand the comment about she received, we can't ignore that either. She received correct advice at the top.
At the beginning.
Okay, now that was muddled
Correct.
in the middle, which probably,
And believed to have changed when
Yes.
when the subsequent petition was filed.
So
Yes.
there's nothing in this record other than miscalculation and then compounded upon miscalculation, ignoring the initial correct advice,
Right.
which is damning to your position, and then again, miscalculation.
So the Whitehead, the second prong of the Whitehead test says that due process tolling can occur when a client is otherwise misled to believe things about her case that are not true. That occurs in extraordinary circumstances.
And that interpreted means that an attorney is working on her case, or doing things to advance the case, not necessarily told things about her case like a miscalculation. I guess I'm trying to understand the difference that you're making, and it's not really, I'm not really receiving
Sure.
it.
It is in part the scale, but there's other factors as well. So let me just start with that. So a single attorney error is one thing. 6 separate sources of information, all confirming that same error, compounds the error. Every single source that the Lowe's consulted confirmed the wrong information. And there were other sources, excuse me, from sources who were not her agents.
So why didn't they just go back and look at the initial letter sent by the initial attorney?
So the post-conviction court found, based on the testimony that was provided at the hearing and relied upon by the court, that the parties all believed that the procedure had changed once they made the decision to go to the U.S. Supreme Court and file their petition there. And based upon that change, the advice changed. And everything else that they learned about the statute of limitations confirmed that advice after they had made the decision to go to the Supreme Court.
This really wasn't a miscalculation problem. That, as I understand it, the time was correctly calculated based upon when counsel thought the time started to run, correct?
So the error was made in determining that the statute of limitations ran.
So it's a
From the
question
Supreme
of
Court.
legal error more, as opposed to miscalculation.
Right. I suppose not a miscalculation of days, so to speak.
Does that make a difference?
Right. The effect is the same
Yes.
for the purposes of where we are. And what ended up happening is that the pervasiveness of this incorrect information, every resource that the Lowe's turned to reconfirmed the incorrect information. There was, it made it all the more reasonable for her to rely on this advice, right? If she's hearing this from every source that she is consulting. The result is that Ms. Lowe could not have reasonably believed otherwise in some sense. And there was no effective way for her to even obtain independent advice. And it shouldn't be held against her that she was diligently exercising her rights. She was trying to protect herself.
I'm sympathetic. I'm very sympathetic to your position, but the law does not support your position, and that's what I'm asking you to help me with. Parts of your brief are advocating, as I understand it, for us to take a different approach in terms of, I guess, equitable tolling of the statute of limitations.
So Whitehead certainly, it talks about extraordinary circumstances. And this court has the power to understand when those extraordinary circumstances happen. And it's our position that it happens in this case. And it is in part because of the pervasiveness of the incorrect information that she received, and also because she received information that was extraneous to her own attorneys that compounded the error. There was information from people who weren't her agents. Attorneys she didn't hire confirmed this information. The state attorney general's website confirmed the wrong information. That should be taken into account as well to understand the extraordinary circumstances that Ms. Lowe faced that would lead her to the conclusion that there was no other reasonable conclusion other than that the advice that she had received.
Is there any case to support the fact that those are extraordinary circumstances that you could point this court to? Because again, I'm sympathetic to your position, I just don't think the law supports you.
There's certainly no case that I found where there are 6 sources of information that are all incorrect and that lead to one erroneous conclusion that led to the missing of the statute of limitations. I do think it's important to note that this is beyond just the agency relationship with her own attorneys. There were other sources of information that were given to her by people who weren't her agents that also confirmed the wrong.
Well, we can't consider that. If we were to consider that, in every case that comes up in this situation, an attorney will say, well, again, I had somebody tell me that the statute of limitations, didn't start to begin until X date. And, we would have to consider that if we accept your argument. So she had a lawyer. She relied on that lawyer's advice, and unfortunately, it was wrong.
It was, and it was confirmed multiple times by multiple sources. So Another piece that should also be considered is that Whitehead specifically says that the due process fundamental demand for justice makes no distinction as to the attorney's state of mind. It does not matter whether this is an intentional act, whether this is just a mere negligent sort of situation. And so Whitehead did away with what it called the unhelpful distinction between attorney negligence and intentional misrepresentation. It's the result to the client that matters. In some sense, this is almost akin to a situation where an attorney conspired against their client to make sure that every source of information that's consulted is wrong. Of course, that's not what happened here, but the effect is the same. And if that were the case, of course, that would be very problematic, and due process certainly would intervene. Because Whitehead says that this unhelpful distinction between intentional behavior and negligence shouldn't exist, what matters for due process purposes is the result on the client. And because of the pervasiveness of the misinformation in this situation, this is an extraordinary situation for which Ms. Lowe should be granted relief. I'm going to turn now to the juror bias issue. The post-conviction court correctly ruled that there was actual bias in the jury that tried the case and that a new trial was warranted. Juror number 17 demonstrated clear bias in the questionnaire. Specifically, she was asked about information, whether she'd heard about the case through the media, family, friends, or any other source. She responded in answer to question number 54 on the questionnaire on the nightly local news. Question 55, have you formed an opinion based on what you have heard? Her answer was yes. If yes, what is your opinion from what you've heard? That she lied and killed her 2 newborns. Number 56, question, if you have an opinion, can you lay that opinion aside and based on the evidence and law reach a fair verdict in this case? And her answer was yes. The preconceived opinion that juror number 17 had, without hearing any evidence in this case, was that Ms. Lowe, number 1, lied, and number 2, killed her 2 newborns. In its brief, the state seeks to parse this language, saying that this doesn't have anything to do with any sort of legal conclusion about guilt. But in layman's terms, when somebody says that a person lied and killed someone else, that indicates that they think a crime was committed. And juror number 17, presumably, having filled out that questionnaire truthfully, walked into that courtroom with that belief.
Is your position that she should have been disqualified based on the questionnaire alone?
No, because she was asked essentially the same 3 set of questions in voir dire, and she didn't give the same answer.
Okay, so she said she could be fair and impartial, and I guess what, the questionnaire is troubling, obviously, but the prosecutor or defense counsel, I think it was the prosecutor or the trial judge, attempted to rehabilitate her. Her answers were she was going to be fair and impartial based on the instructions that were given by the trial judge. So I'm trying to get you to hone in on how she was biased.
Sure. So a couple of points there. You mentioned that there was an attempt to rehabilitate her.
Well, she was asked if she could be fair and impartial after hearing the proof.
She was asked generally about that, but not with any specificity about the statement that was made in the questionnaire. And so rehabilitation must show that must establish unequivocally that any bias that has been elicited in questioning can be set aside. And that question was never put to this juror specifically about the questionnaire, her response in the questionnaire. Now, she was asked sort of a trio of similar questions in one-on-one voir dire, where she was asked, where she had heard about this case, and again, she responded from the nightly news. She was asked, have you gotten any information to the point where you've reached an opinion about whether or not she's guilty? And the response was, no, I haven't.
Do you agree with me that in high-profile cases, that sort of response is common?
Which response, Your Honor?
You've heard about the case in the media. If it's a high-profile case,
of course,
and people are naturally going to have a natural response to what they hear on the news, that's before you go in, before you get instructed, before you hear the proof, that's a natural thing to occur.
Absolutely.
Okay.
No, that was certainly an issue running throughout jury selection in this case, of course. But she gave two different responses. In the questionnaire, she says, I have an opinion, and my opinion is she lied and killed her 2 newborns. And then she's asked a second time, what is your opinion? No, I don't have an opinion about whether she's guilty or not. Those are 2 different answers. And she doesn't explain herself. We don't know why she's changed, but she was given the opportunity to explain herself. Just like counsel for the state said, she had been sitting there. She knew that the impartiality of the jury was what these questions were directed at. And that was the exact moment when she should have voiced, yes, at some point, I did have an opinion. I have expressed that opinion. I've set that opinion aside. But that's not what she said. What she said was something completely different from what she had said in her questionnaire. So the issue is not that she just simply had that she had this position in the questionnaire, is that she had that position. She gave a different answer later. And then also we have the independent, the fact that the judge gave credence to, the post-conviction court judge gave credence to, in the sort of visual celebration that she appears to have done in being selected for the jury. So taking those 3 things together, that's what demonstrates the actual bias in this case.
And maybe I just missed it in the briefs. How did the judge weigh this fist pump? It was their testimony
Yes.
from the victim's father or the
Correct.
defendant's father?
Mr. Mark Lowe, Lindsey Lowe's father, testified at the post-conviction hearing that he was sitting within visual sight of this juror 17 when she was selected, and that she, in essence, gave a bit of a fist pump when she realized that she had been selected for jury duty, and the court credited that observation and that testimony given by Ms. Lowe's father. There was another occasion in voir dire where the state's attorney asked, is there anything in your questionnaires that we haven't touched on that maybe we need to talk about? And again, no response from juror number 17. There were attempts to try to elicit this type of information, but juror 17, frankly, was never as forthright in voir dire as she was in her jury questionnaire. So when you take that lack of candor during voir dire, plus the response that she gave in the questionnaire and the celebration, that's evidence sufficient enough to prove that that she was actually biased and that she ended up on the jury. Finally, turning to the ineffective assistance of counsel claim, which is a second independent basis for reversing the trial court and remanding for a new trial. To prevail on this claim, Ms. Lowe must first establish that trial counsel's representation fell below the objective standard of reasonableness guided by professional norms prevailing at the time of trial. There was ample testimony in the record from attorneys, including one who was qualified as an expert on the standard of care for, or standard of how criminal defense attorneys should operate in these circumstances. And each of them said, of course, there was no way the defense counsel in a criminal case would allow this particular jury to go unquestioned or to be allowed to stay on the jury. No competent attorney would have kept juror number 17 on this jury, was the testimony. The U.S. Supreme Court has acknowledged that in Morgan versus Illinois, that among the most essential responsibilities of defense counsel is to protect their client's constitutional right to a fair trial and impartial jury by using voir dire to identify and ferret out jurors who are biased against the defendant. This was not a question of a strategic decision. This was no decision at all. The testimony of trial counsel was that he, quote, just missed it, end quote. Just missing it, no follow-up. That's not a strategic decision. This is just simply the fact that it went unchecked and there was never a challenge for cause that was attempted, and the remaining peremptory challenge that remained in his pocket was never exercised. The second prong of the ineffective assistance of counsel claim requires Ms. Lowe to show that she was prejudiced by counsel's unprofessional errors. And in this context, under Smith versus State, the petitioner must prove that the deficiency resulted in having a juror seated who was actually biased. And that goes to the previous argument just regarding the independent claim of juror bias. Your Honors, the post-conviction court correctly ordered a new trial, found ineffective assistance of counsel, found that due process was violated by the presence of a single biased juror that remained on the jury, and the post-conviction court properly ordered a new trial. The judgment should be affirmed in all respects.
Thank you.
Thank you. Got 2 minutes, sir.
Thank you, Your Honor. Judge Wood, if I could answer a question you asked the opposing counsel directly. This was the same error at issue in Whitehead. Whitehead considered this to be a miscalculation. So I don't think the fact that the math was wrong, I mean, this is considered miscalculation. Judge McMullen, I hope that you have heard from the petitioner. She has no other argument than scale as being the basis for her attempted the differentiation between this and what the cases clearly say about attorney error. And the attempt to kind of characterize it as a misrepresentation or use a different language about it, we all can agree, and this was your problem, Judge, is that all wrong advice is misleading because it leads the petitioner to think something about the status of the case that's not true. And Whitehead, Holland have all said it doesn't matter if it's just an error about calculation. The client has to bear the attorney's errors when the attorney-client relationship is functioning. Moving quickly to the juror bias issue, I do want to reiterate what would have normally happened if the questioning had happened about the language in the questionnaire. This juror always, constantly, at all stages, affirmed her ability to be impartial like many other jurors. And it is not fair to expect an average person to answer a question that wasn't asked to her. So this idea that she somehow should have known that there was something she needed to be bringing up to everyone when she was answering questions, presumably truthfully, that is just putting an impossible burden. And that's part of the reason why these cases, Irvin versus Dowd, and I cited State versus Howell as an example, that say the ability to set aside a preconceived opinion is what matters. A preconceived opinion alone is not enough to strike a juror. And I do want this court to think about this. This characterization, this attempt to make it seem like this juror was trying to weasel her way on this jury and lie her way on the jury. If that were true, it just defies common sense that she would have answered the questionnaire the way she did in the first place, which was very frank. Thank you, Your Honors. This court should reverse.
Thank you. The court appreciates the argument in this case today. The court's going to take a 10-minute recess at this time.